Pleasure to welcome you all to the session on how to do legal research. I, Parastu, the member of Legal Vidya, welcome you all on the session on how to do legal research to the part of your internship. Now, I would like to introduce today's speaker, our visionary founder, Ms. Sakshi Sharma. She is a dynamic legal professional who has dedicated herself to the empowerment of aspiring lawyers and legal enthusiasts with a profound passion for legal education. Sakshi ma'am studies the work to bridge the gap between academia and practical legal skills. Her commitment to nurturing the next generation of legal minds is evident through Legal Vidya's innovative webinars, workshops, and educational initiatives, which aim to provide invaluable insights into the legal profession. Sakshi Sharma's visionary leadership has made Legal Vidya a cornerstone in the journey of countless individuals seeking to excel in the field of law. She is the author of Breaking into the Legal Field, and she is the compiler of The Truth of the Life. And she has written a number of articles for our institution. Thank you all for joining us today. Over to you, ma'am.
Thank you so much, Paras. Am I audible to everyone? Can someone please confirm if I'm audible? Okay, great. Good morning, everyone. I'm Sakshi Sharma, and thank you so much, Paras, for the introduction. In this session, basically, we'll be talking a bit about legal research and about writing. The writing basically is a part of how you will be writing your research articles on the topics that you are assigned. Paris, if you're free for a minute, please write down the topic or give me a brief idea of what the topic is. You can write it down in the chat box while I begin my presentation. Please let me know once my screen is visible. NDPS Act, okay. Thanks, Paris. So is my screen visible to everyone? Great, thank you so much. So let's begin with our session. The session basically is on legal research and article writing. Firstly, okay, before we begin with the presentation, can someone tell me what do you understand by legal research? What is your idea of legal research, or what do you mean when we say legal research after article writing? You can write it down in the chat box, whatever you believe is legal research and writing. I'll wait for your answers, guys. Anyone, what is legal research? What do you understand by legal research? A brief idea, vague idea, guys. No one? Okay, fine. So I guess we'll begin with the presentation. So research basically is the investigation or experimentation that is aimed at discovering and interpreting of new facts, or where we revise the already accepted theories or laws in the light of new facts, or practical application of such laws or revised theories of laws. बेसिकली इन जनरल सेंस रिसर्च का मतलब क्या है कि आपके पास ऑलरेडी एक कॉन्सेप्ट है इन योर माइंड और यू हैव अ टॉपिक इन योर माइंड एंड व्हाट यू डू इज you discover more, you try to understand more, and you go in depth into that particular topic to find out and create new concepts and new understandings, or to explain the already existing theories. As you can read on the screen, investigation or experimentation aimed at discovery and interpretation of facts, revision of accepted theories or laws in the light of new facts, or practical application of such new or revised theories or laws. And the second point is that it is the creation of new knowledge or the use of existing knowledge in a new and creative manner. Why do we use it in a new and creative manner? To generate new concept, methodologies, and understanding. Now there are various types of research that we use. We'll be dealing with a few of them, and I'll explain them in very brief, and we'll quickly then go to the writing part, which is the most important part. The first one is descriptive, and the second is analytical. Descriptive research basically involves outlining the current state of legal phenomenon, focusing on presenting facts without delving into causation. Basically, it means कि आपके पास एक topic है, you only discuss on that and you don't go on to why, what is the cause of that particular topic, or why that particular law was needed. How do we use it will help us understand descriptive legal research. Now its application is basically used where, or this methodology is basically used to provide an overview of legal issue and establish a baseline of understanding, that is a brief understanding, or document the existing practices. What we do not do in this is that we do not analyze the concept in depth. We have a concept, we just create a basic understanding of it. We don't go in depth and we don't dig into it, that what is the purpose of this particular concept or this particular law. Then we have analytical legal research. Now analytical legal research critically examines existing facts and information, completely opposite to descriptive, because in descriptive we do not try to understand the underlying pattern or implications of a particular law, whereas in analytical we critically examine them to understand the underlying patterns or implications, to dig deeper into the meaning behind a particular legal phenomena or a particular law that is applicable. Now applied legal research. Applied legal research basically seeks a solution to real world problems operating within practical contexts. अप्लाइड से मतलब क्या है कि आपके पास एक थियरी एंड आप उसको एक प्रैक्टिकल सेंस में अप्लाई करना चाहते हो. द नेम इटसेल्फ मेक्स इट क्लियर दैट we seek practical solution to real world problems. Now who uses this? This is basically used by legal practitioners, the lawmakers, the policymakers, and even the advocates to develop strategies and to draft various laws. Then we have fundamental legal research. Fundamental legal research aims to advance theoretical understanding. Who uses this? Basically, the legal scholars and academicians. We often use fundamental legal research to explore abstract legal concept. That is a legal concept that is not very clear, but it exists. We want to understand more on it, right? Or we want to develop new theories. Then we use fundamental legal research. Then we have quantitative legal research. That is the fifth type of legal research. Quantitative का मतलब क्या होता है? Quantitative का मतलब होता है using data and using various measurements to understand the quantifiable aspect of legal research. Basically, quantitative legal research में हम लोग क्या करते हैं? We use various surveys, we use various experiments and discussions. Why? To assess the impact of the legal changes. मान लो नए farm laws आए थे, right? When we use quantitative legal research to analyze those particular farm laws, what we do is we make surveys, we take interviews, we have discussions with groups of people to understand what are the implications of this law on the general public. Then we have qualitative legal research. Qualitative legal research basically explores the quality and characteristic of a legal phenomena or a legal theory or a law. Who uses this? Now, this methodology is often used to explore complex social and cultural aspects of law and to understand the experiences of marginalized communities. Then we have the last four kinds, which are mostly used apart from the quantitative, that is the conceptual, empirical, doctrinal, and non-doctrinal. Most of you would already be familiar with doctrinal and non-doctrinal, या फिर आपने कभी ना कभी सुना ही होगा. तो पहले अपन conceptual की बात करते हैं. Conceptual legal research, it engages with abstract theories or ideas commonly used by philosophers to reinterpret or develop existing legal theories, contributing to theoretical framework. अब इसको समझने के लिए what you can do is, I'll give you an example. जब भी आप लॉ पढ़ते हो और आप डेफिनेशन पढ़ते हो किसी चीज की, मान लो यू आर रीडिंग द सब्जेक्ट ज्यूरिस्प्रूडेंस, ज्यूरिस्प्रूडेंस में हर एक थियोरी, देयर आर वेरियस थियोरीज, राइट, given by various jurists. Now all these jurists, what they do is they take each other's ideas or create their own ideas to contribute to the theoretical framework. चलो मान लो हम लोग लॉ की ही डेफिनेशन लेते हैं, लॉ की कितनी सारी ही डेफिनेशंस पढ़ी होंगी आपने फ्रॉम योर फर्स्ट ईयर टू योर लास्ट ईयर, एंड वुड इवन बी रीडिंग while you're writing your research papers, right? Every jurist has his own interpretation of what law is and how it works. Now what they have done is they have used conceptual legal research to reinterpret and to develop a legal concept. What is the legal concept at the case in hand? That is law, what law is. So every jurist has used their own philosophy, their own upbringing, understanding of what law is to create basically a theory and a definition surrounding it. Then we have empirical legal research. Empirical legal research relies on observation and experimentation. What we do in this is we utilize data and facts to substantiate our hypothesis. Hypothesis is basically, you can say, the questions that you create on why you're writing a research paper. ठीक है, what you do in empirical legal research is आप evidence gather करते हो to challenge your legal theory or to prove your legal theory or your question. Then we have the most commonly used one, doctrinal legal research, which by the way is the one that you will be using in writing your research articles while you're interning under us. Doctrinal legal research is basically लाइब्रेरी बेस्ड लीगल रिसर्च, जहाँ पे आप अपने घर के कंफर्ट से, लाइब्रेरी के कंफर्ट से ऑलरेडी एग्जिस्टिंग डेटा उठा के अपने पेपर्स लिखते हो. This is most commonly used practice. What people do is they analyze the legal principles, statutes, and case laws through various legal resources. Why? To understand a legal doctrine or a particular topic and their application. Then we have non-doctrinal legal research. Non-doctrinal legal research is completely opposite. जहाँ पे doctrinal legal research को मैंने बोला it is a library-based legal research. इसका मतलब क्या है? आपके पास sources already, आपके पास books है, you have your bare acts, you have your textbooks, you have your commentaries, you have internet as a source. आप बस information gather करते हो, उसको analyze करते हो और लिखते हो. But non-doctrinal में क्या होता है कि you try to understand the law in a much deeper sense. How do you do it? You go outside, you understand how law is impacting people. And non-doctrinal legal research often involves law and other fields such as history, sociology, anthropology to understand a legal concept or a legal issue in a broader sense. That is, we're not just focused on what law is, या फिर चलो मान लो आपको arbitration पे topic मिला है arbitration agreement का, ठीक है, आपको arbitration agreement का topic मिला है, you're just not focused on what arbitration agreement is. आप उसके history में जाते हो कि कहाँ से आया, क्यों आया, इसका impact क्या पड़ रहा है in the present, क्या था जब what was the scenario when there was no concept of the Arbitration and Conciliation Act, when there was no concept of arbitration agreement, क्या तब arbitrations होते थे, अगर होते थे तो कैसे होते थे, right? You go beyond your legal textbook, beyond the case laws that exist to understand a particular concept. That is known as non-doctrinal legal research. Now this is where you'll have to pay the most attention on how you'll write your articles. The first point is, what is your research question? Then when we talk about research question, basically जब आप articles लिखते हो या फिर जब आप submit करने जाते हो अपने articles, you always come up with a legal question which you analyze, you investigate on, and then you write your research paper. But in this case, while you're interning under us, you don't have to go through the hassle of finding your research question. We have given you a specific topic or an issue at hand. what you'll have to do is you'll have to understand what that question is. Sometimes it can directly be a section that we're talking about. Sometimes it can be a critical analysis of a particular section. Sometimes it can be interpreting a particular section in various senses, right? अब मान लो हम बात करते हैं आर्टिकल 21 की, ठीक है? आर्टिकल 21 कितना, 2 लाइन का तो आर्टिकल है, 2 लाइन का भी आर्टिकल नहीं है, राइट? बट इफ समवन इज राइटिंग ऑन article 21, will they just stop writing after 2 lines? No. What they'll do, they'll try to delve deep into the particular concept, analyze various aspects of that particular law, and then they'll go ahead to understand what article 21 is and then write the research paper. So if you can see, there are 3 concepts here, 3 questions here. The first is, what specific topic or issue are you investigating? The second is, are there any particular aspects or dimensions of this topic you want to explore? And third is, how will your research question contribute to the existing knowledge? What? Yes, Paras?
मैम आपकी फर्स्ट स्लाइड पे दिखा रही है अभी तक PPT.
Okay, I'm so sorry. Let me just check. Let me reshare my screen. Please let me know. Okay. Is the screen visible?
Yes.
Okay. So, chalo फिर से we'll talk about steps to writing. As I was talking, the first point in writing is understanding your research question. तो जब हम research question की बात करते हैं, what you need to understand is there any specific aspect that you want to explore and you want to write about, या फिर आपके पास already एक particular topic है that is very specific, so you don't want to go or delve deeper. मान लो आपको अभी research questions मिला, आपको अभी topics मिले by your internship coordinator to write articles on. You can stick to that, but what you can also do is you can delve deeper and write it in a more enhanced way. आप उसके particular concepts अच्छे से explain कर सकते हो, and so on and so forth, right? तो सबसे पहला चीज in writing your research paper is understanding your question. How can you understand it? अगर आपको मान लो NDPS Act के बारे में question मिला, NDPS Act से related question मिला, and you have never read that act, you cannot write an article until and unless you read on the topic, right? Or you understand the particular question. First thing that act suggests you do is ओपन द बेयर एक्ट. मान लो आपको सेक्शन 5 या 6 के बारे में मिला है, पढ़ो सेक्शन 5 या 6 क्या है. 1-2 बार नहीं समझ आए, 3 बार पढ़ो, 4 बार पढ़ो, watch videos, try to understand what section 5 and 6 is. After, it is only after you understand your research question you'll understand how you want to write. So the first point is understanding your research question. The second is identifying your headings and subheadings. Now, why is this important? अब अगर आप हेडिंग और सब हेडिंग स्पेसिफाई नहीं करते हो, प्रॉब्लम ये आती है कि आपके आर्टिकल में लोगों को पता नहीं चलता आप किस किस चीजों के बारे में बात करना चाहते हो. सो ऑलवेज व्हेन यू आर राइटिंग योर आर्टिकल, स्पेसिफाई द हेडिंग्स एंड सब हेडिंग्स क्लियरली so that the people can know what is the main what are the main categories that you're dealing with in your particular article, what is the theme of your research, एंड क्या वो उनके काम के है भी या नहीं. बिकॉज आप सिर्फ आर्टिकल इंटर्नशिप कंप्लीट करने के लिए नहीं लिख रहे हो, यू आर राइटिंग because other people will come and also read through your articles, so you want those articles to be impactful in some way or other, right? So मान लो आप लिख रहे हो आर्टिकल 21 के बारे में, आप सिर्फ आर्टिकल 21 हेडिंग लिख के तो नहीं छोड़ोगे ना. There will be various headings like the history of Article 21, the background of Article 21, then Article 21 and the concept pre-independence, post-independence, in modern era, various what do you say, various aspects of Article 21. Article 21 is not just right to life. Article 21 में और भी चीजें आती है, right? There's also right to die in Article 21. तो right to die क्यों है? There's right to internet, there's right to अ गुड लिविंग एनवायरनमेंट। तो ये सब क्यों है, कैसे है, क्या है, वो भी तो आप एक्सप्लोर करोगे। तो आपका एक मेन थीम है, उस मेन थीम के बाद आपके हेडिंग्स और सब हेडिंग्स है। यू हैव टू स्पेसिफाई दोस हेडिंग्स एंड सब हेडिंग्स to make it clear to the audience that you're reaching through, that why you have written this article and what are the concepts that you'll be dealing with. Now before I continue, can someone please tell me, confirm, turn on your mics and confirm if my screen has changed?
No, it is not.
uh, right, give me a moment. Can you all see the screen? It's written making a rough and filling information.
Yes.
Okay, thank you so much. So the third point is making a draft and filling an information. ना जब आपने अपने हेडिंग्स एंड सब हेडिंग स्पेसिफाई कर लिए तो आपके पास एक आइडिया है ऑन व्हाट यू वांट टू राइट, राइट? यू हैव your topics that you want to delve deeper into and write. Then what you do is, first you make a rough draft, gather all the information, collect it, and then you start framing your article. Your article must always be in a chronological order. ऐसा नहीं कि एक मतलब मान लो आप किसी चीज की हिस्ट्री के बारे में बात कर रहे हो, यू आर स्टार्टिंग फ्रॉम 1880, बीच में आपने 1990 डाल दिया, फिर आपने 2011 डाल दिया, फिर आपने 1995 डाल दिया, दैट वोंट मेक एनी सेंस, राइट? तो हमेशा जब भी आप एक रफ ड्राफ्ट बनाओ, उसके बाद जब आप एक फाइनल ड्राफ्ट बना रहे हो, मेक श्योर योर आर्टिकल मेक सेंस, इट इज इन अ क्रोनोलॉजिकल ऑर्डर, एंड डू नॉट कट कॉपी पेस्ट, क्योंकि अगर आप कट कॉपी पेस्ट करोगे एंड जब आप अपना आर्टिकल खुद पढ़ोगे, यू विल रियलाइज दैट many a times it is your sentences are very different from one another. There's a lot of grammatical issue and you're not able to the sentences just don't make sense. So make a rough draft, fill in your information, then properly write your headings and subheadings, and देखो कि आपने जो चीज लिखी है whether it relates to the heading or subheading or not. पता चला आपने हिस्ट्री में बैकग्राउंड डाल दिया, बैकग्राउंड में हिस्ट्री डाल दिया, that won't make any sense. Always ensure that whatever information you're writing aligns with your headings and subheadings, and then revise and edit. Obviously, once you have written your article, go to your read it once, twice, thrice, ensure that it is grammatically correct, ensure that the information that you're putting is accurate. You cannot, मान लो आप आर्बिट्रेशन के बारे में बात कर रहे हो और मान लो 2021-22 में कोई अमेंडमेंट आया है एंड आप कब की बात कर रहे हो, you're still stuck in 1996. It won't make sense because your article does not include the latest amendment. Always ensure that you always ensure कि आप जो भी लिख रहे हो that is up to the mark, firstly, and it is relevant. Third, it is accurate, that is it is factually and legally correct, and आपने जो लेटेस्ट अमेंडमेंट्स है उनको भी इनकॉर्पोरेट किया है अपने आर्टिकल में, बिकॉज इफ यू डू नॉट डू दैट देन योर आर्टिकल इज जस्ट ब्लैंक एंड बेसिकली आप एक पुराना लॉ एनालाइज करके बैठ गए हो। मान लो नए अमेंडमेंट्स में हद से ज्यादा चेंजेस हुए, देयर आर अ लॉट ऑफ चेंजेस, so the new one is relevant to people, right? They will be searching for the new one, and आप पुराना लिख के बैठ गए, then your article is of no use to the people who are coming to your article to read it. So ensure कि आप latest information लिखो, that should be correct. Now, did my screen change, Paris? Am I audible?
Yes.
Okay, thank you so much. Now, the points to remember while you're writing your article. 4 main points. Firstly, the length of your article. अब आपको टॉपिक मिला as far as written in the group that relates to NDPS and arbitration. Both of them are fairly new topics, I'd say, and there are not too many articles on them. Now, length of your article basically means that you cannot write just 200 or 300 or 400 words and call it a day. We want you to write articles that explain each and every point very nicely. So the minimum length of your article will be around 1,000 words. 1,000 words से ज़्यादा लिखो very well, but at least reach that minimum length of 1,000 words, because 1,000 words is something that we expect from you when you're writing your article. अगर आप 200-300 शब्द लिखोगे, it's more like an essay, or I'd say a छोटा सा synopsis that you're writing, and it will not explain everything in detail. So minimum 1,000 words is what you need to write. Then the language and grammar, जैसे मैंने बोला कि many people, even I had the tendency of cut copy paste किया, हो गया चलो article खत्म. But जब हम वो करते हैं, the language and grammar, they do not match with one another. One sentence is in past tense, one is in present, one is in active voice, one is in passive voice. That will not make any sense to the reader, and it will be clear that the writer of the article or the author of the article, what he has done is he has taken information from somewhere and has not put effort in even reading his or her own article to ensure that it is grammatically correct and its language is correct. We do not want that. So always ensure that your language and grammar are correct. Then the third thing is scannability. तो जब हम लोग हेडिंग्स एंड सब हेडिंग्स की बात कर रहे थे, वी टॉक्ड अबाउट हेडिंग्स एंड सब हेडिंग्स देना क्यों जरूरी है. हेडिंग्स एंड सब हेडिंग्स देना इसलिए जरूरी है सो एज टू एंश्योर कि जो रीडर है, मान लो किसी के पास सिर्फ 10 मिनट है और उसे एक टॉपिक पे प्रेजेंटेशन देनी है, इफ ही गोज थ्रू आर्टिकल्स एंड सीज हेडिंग्स एंड सब हेडिंग्स, उसे पता चलेगा ये आर्टिकल रिलेवेंट है या नहीं. ठीक है, वो उसको पहले तो स्कैन करेगा, स्किम करेगा टू एंश्योर कि वो रेलेवेंट है या नहीं. To ensure that, what you need to do is you need to show your headings and subheadings. So scannability is also one important aspect. Always identify your headings and subheadings properly. And the fourth is explaining legal jargons. As law students, as lawyers, हम सबकी ये I'd say we have this thing where we all use tons of Latin maxims and fancy English words which we do not bother to explain. मान लो कोई फर्स्ट ईयर का स्टूडेंट है एंड आपके आर्टिकल्स में 1,000 तो आपने लीगल जार्गन भर दिए. अब उस बंदे को समझ ही नहीं आ रहा, उसे हर 2 मिनट में डिक्शनरी खोलनी पड़ रही है, उसे गूगल करना पड़ रहा है कि शब्द का मतलब क्या है. एक तो उसका पढ़ने का फ्लो बिगड़ जाएगा, एंड सेकेंडली ही विल थिंक दैट यार इस बंदे ने लिखा तो बढ़िया है बट ऐसी लैंग्वेज में लिखा है जो मेरे को समझ ही नहीं आ रहा, मैं इसको क्या पढ़ूं, मैं दूसरे आर्टिकल पे चला जाता हूँ वेयर द थिंग्स आर एक्सप्लेन्ड. तो incorporate legal jargons wherever necessary, but if you are incorporating them, do not forget to explain them. आपका आर्टिकल ऐसा होना चाहिए कि एक फर्स्ट ईयर का स्टूडेंट, a normal person, a layman, and a teacher, a lawyer and a teacher and anyone who is a legal professional, वो तीनों को समझ आए. तो ऐसी भाषा में अपने आर्टिकल्स लिखो, ऐसे लैंग्वेज में अपने आर्टिकल्स लिखो where your article talks for yourself and it communicates your ideas very clearly and explain the legal jargons properly. Now there are a few things that you'll have to incorporate in your article. The first one is abstract and keywords. Abstract basically is a summary of your whole article which outlines the main points that you will be dealing with. Maximum कितने शब्द, 100 से 250 words. Maximum 100 to 250 words you'll use while writing your abstract. Then there's keywords. Keywords basically are key phrases that will help people, understand what the particular person is dealing with. मान लो your article is on arbitration, your section 7 of Arbitration Act. Your keywords can include arbitration agreement. Your keywords can include section 7 of ANC Act, Arbitration and Conciliation Act, arbitration, and some other similar terms that are popular that will help a reader understand that this person in this article is talking about these specific things. So the first thing that you'll have to write in your article is your abstract and keywords. Secondly comes the introduction and background part. Introduction basically serves as introduction of the topic, and it outlines the purpose of why you're doing this particular research, or why you've chosen this particular topic. Now, then there's background. Background basically is a subsection where you provide historical context of a particular law. मान लो we are talking about uh, say for example we are talking about arbitration agreement only. हम लोग section 7 लिखेंगे, but we'll also delve into the background of section 7 कि ये act कैसे आया, या फिर what was the purpose of incorporating section 7, why was it necessary. So firstly abstract keywords, then we will come to your introduction part जहाँ पे आप introduce करोगे अपने topic को, and you will write what is the purpose of researching on this topic and what is the overview कि आप कौन कौन सी चीजों को एड्रेस कर रहे हो अपने पर्टिकुलर रिसर्च आर्टिकल में. एंड देन विल हैव द बैकग्राउंड जहाँ पे आप लेजिस्लेटिव हिस्ट्री बताओगे या फिर आप रेलेवेंट केस लॉज या केस प्रेसिडेंट बताओगे रिलेटिंग टू योर पर्टिकुलर टॉपिक. Then is the main body, which has main arguments, supportive evidence, and analysis. So main body के section में what all is included? You'll explain your topic clearly. मान लो your topic in this section. Firstly, you'll have main arguments. Basically, you'll present the arguments or your points on your article. By arguments, I mean in this case, that is in the case of your research articles that you write, you'll basically explain each and every concept relating to the particular topic that you are assigned. And now manlo, let's take an easier example of article 21. Manlo, we are saying right to die is also a part of article 21. What we'll write in the main body? First, we'll write what right to die is or what euthanasia is. Then we'll write the supporting evidence. Legal aspect में supporting evidence क्या होता है? Legal aspect में supporting evidence होता है relevant case laws. We'll write relevant case laws that relate to right to die, and if there are any foreign regulations जहाँ पे लोगों के right to die को माना गया हो, right? We'll write that. Then we'll also analyze. That is, we'll analyze कि हम करना क्या चाहते हैं, हम arguments किस चीज पे दे रहे हैं. The analysis section will discuss how you interpret and apply legal authorities and principles in relation to your arguments. Now analysis specifically हम तब करते हैं जब हम एक hypothesis लेते हैं, जब हम research questions लेते हैं to prove or disprove something. But since you're not taking a hypothesis here to prove or disprove something, your research article in its body part will only contain the main arguments and the supporting evidence that is relevant case laws. Then there's the conclusion part, that is the final, and I'd say also one of the most important parts, because बिना conclusion के article मत submit करना, guys will not accept that. Conclusion में क्या होगा कि आप summary लिखोगे, समराइज करोगे कि आपने अपने आर्टिकल में कौन कौन से की पॉइंट्स को डिस्कस किया है, व्हाट वर योर फाइंडिंग्स इन योर आर्टिकल एंड व्हाट वर योर अंडरस्टैंडिंग्स, एंड देन you will also see the implications. You'll discuss key how your research has contributed to the existing knowledge. That is, मान लो आपने कुछ और नई चीजें पता करी हो which very few people know about, how you have impacted the existing knowledge that is already present, or how your research article informs practical decision making will be in your conclusion part. So basically summarize your article, reiterate your key points जो आपने अपने main body में discuss करे, and also write how your research article has helped the society or the existing knowledge. So format में basically let's discuss again. The first thing is abstract and keywords, which is the first part. Abstract जो है, it is a concise summary of your article in 100 to 250 words, and keywords are specific terms or phrases that you use so that the people or the readers are able to identify the relevance of your work. Then there's the introduction part, in which we have the introduction and the background. In introduction, we introduce our topic in brief and outline why we are doing this particular research or what is the overview of the specific legal issue that you're dealing with. In the background section, we write the historical background, the legislative history, or relevant case precedents if there are any. Then the third point is the main body, in which we have arguments, where you write more, delve deeper into your article, write more on it, and you attach your supporting evidence, that is various statutes, regulations, rules, or case laws or articles to ensure your reasoning of whatever you have written. And the fourth part is conclusion, in which there is summary and implication, where you summarize your articles and write how your research has contributed to the existing knowledge. Now, when we talk about legal research, there are mainly three sources which we rely on: the primary, secondary, and the tertiary. Primary ones are the original source of law and that directly establish legal rules. इसका मतलब क्या है? Primary source का basically आप statutes या फिर case laws को refer कर रहे हो directly. So primary resources include statutes, regulations, case laws, treaties, and administrative decisions. Then there's the secondary source, that is basically analysis of primary ones, that which includes articles जो कि scholars लिखते हैं. Then we have law reviews जो and then we have the commentaries and we have textbooks जो कि आप लोग काफी बार refer करते होंगे while you're reading for your exams as well. तो जो भी textbooks आप पढ़ते हो, जो भी आप scholarly work पढ़ते हो, जो भी आप research articles पढ़ते हो, they are all secondary sources of research. Then the third is tertiary. Tertiary basically is the compilation of primary and secondary resources. और ये क्यों बनता है? ये बनता है for a general understanding, to make it easier for people to understand what law is, right? So अब कोई भी इंसान अगर tertiary legal resource से पढ़ रहा है, what they are reading, they're reading legal guides, legal handbooks, legal indexes, and etc. तो ये ना कोई भी लेमैन भी पढ़ के समझ सकता है. It is basically for a general understanding. The last and the most important part is the plagiarism. Now, when you're writing articles for Legal Vidya, the maximum plagiarism that we allow is 10%. So, जब भी आप अपने articles लिखो, you'll always have to submit your article along with a plagiarism report, which should be less than 10%. If it is more than 10%, your articles will not be published no matter how good they are. तो प्लेजरिज्म क्या होता है? प्लेजरिज्म बेसिकली होता है आप किसी और की रिसर्च को, किसी और के वर्क को यूज कर रहे हो विदाउट गिविंग देम प्रॉपर क्रेडिट. दैट इज प्लेजरिज्म. कैसे अवॉइड करें? वेरी सिंपल and very easy. The first thing is cite your sources properly. अगर आप किसी चीज को यूज कर रहे हो तो उसे सही से साइट करो, उसे सही से क्रेडिट दो ऑथर को जिसका भी आप वर्क साइट कर रहे हो. मान लो यू आर राइटिंग योर आर्टिकल ऑन आर्बिट्रेशन and you come across a research article which is very relevant to you. Okay, if you come across that, give credit to the author जिसके आर्टिकल्स आपने पढ़ा है and write it there कि मैंने इसके आर्टिकल से ये लाइन चेपी है. Then use quotation marks. Quotation marks are specifically used जब भी आप किसी के बोले हुए शब्दों को exact word to word quote कर रहे हो. Say for example, a judge has said something in his decision, quote it. If you're using a quotation said by a famous person, put it in quotation marks, make it italics या जो भी करना है, and then cite it कि इस चीज को मैंने यहाँ से लिया है and this person has said this. Then पैराफ्रेज इफेक्टिवली. अगर आप पैराफ्रेज कर भी रहे हो किसी के काम को तो एक पहले तो सही से करो, और कर रहे हो तो तब भी साइटेशन दो. मान लो किसी का रिसर्च आर्टिकल है एंड दे हैव रिटन ABCD एंड आपने कर दिया BACD. दैट डजंट मीन कि आपने कॉपी पेस्ट नहीं किया है. You have still copy pasted it because you have used their idea and their understanding. So even if you paraphrase, give them due credit. if you're using someone's ideas, you're using someone's theories, आपने उनकी आइडिया या थियरी कहाँ से ली है, whether it is from a textbook, it is from a research paper, it is from a work that they have done, you have used it to write your research article, fair enough, but give them due credit again. रेफरेंस फैक्ट्स ना, कई बार क्या होता है कि हम लोग लॉ कमीशन की रिपोर्ट्स को साइट करते हैं जहाँ पे उन्होंने कुछ डेटा दिया होता है, हम लोग एनसीआरबी की रिपोर्ट्स को साइट करते हैं जहाँ पे उन्होंने कुछ डेटा दिया होता है. नाउ दोज आर फैक्ट्स जो आपने किसी जगह से उठाए हैं. तो अगर आपने उठाए हैं, यू नीड टू मेंशन कि आपने वो चीज कहाँ से ली है, सो दैट द रीडर कैन रिफर टू द ओरिजिनल सोर्स एंड इंश्योर कि जो भी वो इंफॉर्मेशन पढ़ रहा है वो सही पढ़ रहा है या नहीं. देन मैनेज योर नोट्स. बेसिकली जब भी आप एक रफ ड्राफ्ट बनाते हो, ऑलवेज राइट कि आपने कौन सी चीज कहाँ से ली है. एंड जब आप अपना फाइनल ड्राफ्ट बनाते हो तो एंश्योर कि अगर आपने वो चीज अपने फाइनल ड्राफ्ट में इनकॉर्पोरेट की है, यू आर गिविंग देम ड्यू क्रेडिट. Then use plagiarism detection tools. Now there are many plagiarism detection tools, like paid wale hai, there's Drillbit, there's Turnitin. Then free wale hai, like Dupli Checker, there's small SEO tools and many others. Always use those plagiarism detection tools to ensure कि आपका जो भी article है, it is under the limit. Then avoid patch writing. पैच राइटिंग बेसिकली मीन्स कि आप एक कोशिश करते हो कि आप दूसरों का जो भी वर्क है वो अपने ओन वर्ड्स में लिखो कंप्लीटली. नाउ सिमिलर टू पैराफ्रेजिंग, पहले तो इसको अवॉइड करो. अगर अवॉइड नहीं कर सकते, करना ही चाह रहे हो, तो प्लीज 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 गिव ड्यू क्रेडिट, बिकॉज प्लेजरिज्म इज नॉट जस्ट unethical, it is also illegal if you all know according to the guidelines. And अगर प्लेजरिज्म फिर भी कम नहीं हो रहा, यू ऑलवेज हैव योर इंटर्नशिप कोऑर्डिनेटर्स टू कॉन्टैक्ट टू, जो आपको बता देंगे व्हाट यू कैन डू एंड हाउ यू कैन ensure that the plagiarism is reduced. Now that is it that I had to discuss with you all. If any one of you has any query, you can just write it down in the chat box and I'll answer them now. If anyone has any query, please let me know. Paris, I don't believe there are any questions. Thank you so much. Can we change the format as per the topic? Yeah, you can definitely change the format as per the topic. Completely upon you. But ensure that you incorporate whatever is mentioned.
What is the difference between abstract and summary?
So basically in abstract is what you write in the starting of your article, and what it does is it basically explains your whole article in brief. जब आप एब्स्ट्रैक्ट लिखते हो, आप क्या क्या लिखते हो, पहले तो ये समझो. यू राइट व्हाट योर टॉपिक इज, व्हाट योर डीलिंग विद, व्हाट आर द पॉइंट्स दैट यू विल कवर एंड व्हाट योर फाइंडिंग्स विल बी. बट जब हम समरी की बात करते हैं, समरी बेसिकली सिर्फ एक टॉपिक का ओवरव्यू देता है, ठीक है. वी डू नॉट इंक्लूड एवरीथिंग इन आवर रिसर्च आर्टिकल जो भी हम लिख रहे हैं. एब्स्ट्रैक्ट इज व्हाट यू राइट एट द स्टार्टिंग टू give readers an idea कि आप किस चीज के बारे में लिख रहे हो एंड आप अपने आर्टिकल में क्या क्या चीजों से डील करोगे एंड व्हाट योर रिसर्च क्वेश्चन बेसिकली इज. बट जब आप समरी की बात करते हो, समरी बेसिकली इन जनरल सेंस मीन्स कि आप अपने टॉपिक का एक समराइज्ड फॉर्म में अंडरस्टैंडिंग दे रहे हो लोगों को. सो एब्स्ट्रैक्ट को एब्स्ट्रैक्ट एंड समरी आर टू वेरी सिमिलर कॉन्सेप्ट्स I'd say, बट यूज इनका बहुत डिफरेंट है. एब्स्ट्रैक्ट आप रिसर्च आर्टिकल्स में लिखते हो सबसे ऊपर टू गिव एन अंडरस्टैंडिंग कि आप लिखना क्या चाह रहे हो, आप कहना क्या चाह रहे हो. You're welcome. Anyone else? Are you talking? You're talking about Harvard Blue Book, right? So Blue Book basically is really easy. We'll also give you a format. We'll also give you a Blue Book and also give some, examples on how you can cite. You just refer to them, and even if after referring you're not able to understand the citations, you can always contact us, and we'll help you with them. Yogita, you're welcome. Anyone else? I don't think there are any more. So, thank you everyone for joining the session. And if anytime during your internship you face any problem, you can always reach your internship coordinator and they'll help you out.